Okay. Well, welcome everybody. So glad that you are here for this program. And I am going to hand it over to Randy, who's going to do the introductions.
Good morning. I'm Randy Sullivan of Penn Sullivan Brodell, the program director. This year, I'd like to give a quick introduction for our speakers. We have Carol Langford. She's held a number of leadership roles in the area of ethics. She's a faculty member at USF, regular speaker, author, including, for instance, LexisNexis's publication, Legal Ethics in the Practice of Law. She's also a qualified expert witness in the area of ethics. We also have Robert Miller. He's a partner at Lubin in their business, real estate, and land use practice. He represents individuals in all aspects of their real estate and related development, and in particular, home builders and residential developers. He was previously general counsel at Braddock and Logan, and I'm going to turn it over to them. Hopefully everyone has the ethical scenarios and can use the Q&A feature through Zoom, and I'll try to monitor that and jump in without interrupting the flow today. So with that, I'd like to turn it over to our speakers.
Okay, I'll just start and present quickly what the facts are, the hypotheticals, and for people that don't have it by any chance. You're representing Knights of the Round Table. It's an institutional client. It's a real estate transaction. The seller is Michael Modred, and he's a sophisticated landowner. And so the issue arises because he doesn't have a lawyer in the transaction. He has a DUI lawyer that he's used before, and he doesn't think that he needs to worry about having a lawyer. And so questions come up about, you know, him wanting to save money and perhaps rely on you to give him advice too. So you'd be giving advice to the buyer and the seller. And you also have a third-party payor for your client. In other words, your client isn't paying. And there's perhaps a provisionally licensed lawyer who is involved. So I'm going to just start briefly and then turn it over to Robert by talking about provisional licensing, because right now people don't know it, but it's going to be, I think, a big thing in California. I was appointed by the Cal Bar and the Supreme Court to write the provisional licensing for lawyers. We are now looking at public comment, and the Supreme Court ordered it. So you need to know that this wasn't something that me or the bar or anybody came up with. Supreme Court ordered it. Many states have what's called diploma privilege. People do not have to take the bar. Those are in states where they don't have a lot of ABA accredited schools. They have one or two schools. They're both ABA accredited. And it's not like us, where we have a lot of different kinds of schools. So it's very hard to say no bar exam for us. So what is provisional licensing? What it's going to be is it's going to be a law student, and they're going to graduate this year. They are going to be able to practice law without a bar exam result and without a clearance of moral character. This is going to go on for probably till 2022. They are allowed to take as many bar exams as they want. I think that's about 4 bar exams in that time. They do not have to clear moral character. Now, lest any of you worry about that, I worry about it because I represent students in moral character. You really don't have to, because a very small percentage of students actually go to hearing in moral character, and they are not allowed to handle trust accounts. So they won't be able to do that. All they have to do is attest that they have a job offer. And they can work outside of California as long as they work for an entity with an office in California and they are supervised. So I would say for all of you folks, if you get a law student that says, hey, I'm provisionally licensed, it's like having a certified law student. They can do more though, because they can go into court, they can do trials. The key is supervision, and how much supervision they're going to need depends on the case. But I think it's a great program for these students who are worried about loans, who are worried about getting jobs, who, you know, don't have good connectivity for the bar exam. This gives them a shot. So know that that's coming, whether we want it or not. Supreme Court has said we're going to do it, and the rules should be out shortly. And I'll turn it over to you, Robert.
Okay, thanks, Carol. That's news to me. That's a new program. I haven't heard of that. So it's interesting to know that that's a possibility now. So this is a scenario that I've actually had things like this happen to me where the business person on the other side doesn't have an attorney. And you have to be careful when you're dealing with this situation that they can't claim that they thought you were representing them, which obviously, you know, you wouldn't do that intentionally, but it can happen where they could claim later, well, he seemed to be, you know, talking about what was fair and what was reasonable. So I thought he was doing, you know, he's being fair and reasonable to me, and I didn't know better. So the fundamental thing here is to just, you know, be clear when you're talking to these people that I don't represent you, confirm that in writing. And, you know, whenever this kind of statement comes up, it's like, oh, well, you're doing such a great job. Just keep on, you know, I trust you, and whatever you say is fair. Say, hey, you know, you need to know I don't represent you, and you should get an attorney. There's some sort of forks in the road here that we talk about in the hypotheticals. Do you have any obligation to Mr. Mordred to advise him to get representation? I think it's good practice to tell him to get representation, that if he isn't represented, even if he doesn't say, I'm relying on you, you should tell that person so that the question doesn't come up later. Well, you know, shucks, I'm just a poor old farmer here and I don't know what's going on and I was taken advantage of. So you should, you know, in this day of email, it's very easy to create a written record that says, you know, dear Mr. Mordred, I see that you're not represented. I strongly advise you to get represented. This is a, you know, complex transaction. I'm only representing Knights. My client is Knights, and I'm going to represent Knights to the best of my ability. I do not represent you and will not represent you. I mean, I think that should be said in writing at some point.
You have to be disciplined on that. And it's hard sometimes, you know, when you have two people. I get that sometimes even. And, you know, I force myself. I say, Carol, this is what you teach. You got to do it yourself. To make sure I send that email in writing. If it's Lawyers Mutual Insurance Company will tell you, if something's in writing, it happened. If it's not in writing, it didn't.
Right. Yeah.
And so you have to be very disciplined about that.
Yeah. I mean, you don't want to be in a position where he says, well, I don't remember him saying that. I don't, you know, if he said it, I didn't hear it. You know, I don't know. So, you know, it's very easy right now with email. There's so many ways to communicate, but to put it in email, it's just, there's a permanent record then. The next part is, what if Mordred tells you that he has an attorney that he used for his DUI and other personal criminal matters, but he doesn't carry malpractice insurance, but he doesn't want you to talk to that person? Well, I mean, all you can do is say, you know, do you have an attorney that you want me to talk to? And if he says no, then you can't talk to somebody. But if there is an attorney who represents this person, you have to advise that person, like, I can't talk to you. I need to talk to your attorney. Please have your attorney, or please give me the name of your attorney so I can talk to that person.
Well, and you know, Robert, what he did with that DUI attorney is tell him, oh, I'm doing a deal. It's real simple. I just want you to look it over. And the guy's a DUI attorney. He doesn't do, you know, criminal defense lawyer. He doesn't even do this kind of work. And the attorney actually is going to be the one to rely on you too, because he's going to call you up. Look, I don't do this much, but, you know, they both agree on the terms. So is there any big issues you see? That's what's going to happen. And then he's going to rely on you.
Well, I'm less worried about that. I mean, he has his own malpractice. He can't rely on me. He's an attorney.
But he has no malpractice insurance.
Oh, well, there you go. Okay.
Yeah. Okay. And there's a third party payor, which comes up, and that just, you know, the only thing with a third party payor that I think comes up for me, and I don't know about you, is because people are paying, even though you tell them, my independence of judgment is going to be towards my actual client, and I'm not going to listen to you, basically, and you have no right to confidences of the true client. People still expect something when they're paying, and they can be demanding. I've had that with when I represent students, for example, in moral character hearings, and the parents are paying. And then the parents will want to know what's going on with the case. And the students don't want their parents to know the shenanigans they were up to. So even though you tell them that, I find sometimes it still comes up where payors expect to have rights. Do you ever see that, Robert?
You know, this doesn't come up in my practice that often where there's a third party payor, because I have, you know, more institutional, you know, organizational clients. Mm-hmm. So I could see how if you had individuals, I have had it where, you know, there's there's multiple people and only one of them is more institutional than the others. And that person, I think, does kind of get the feeling like, hey, I'm paying the piper, so I get to call the shots. And
they
call the tune. And the answer is, I mean, and when that situation happens where you have multiple clients and only one of them is paying, you do have to disclose to them what the rules are, and that they're all clients, and that there's, the confidentiality of communications among them has to be waived, and you may have to withdraw. I mean, if there's a conflict, you may have to withdraw. So that's kind of the standard multiple client issue. In this example, we have just the pure third-party payor, and I think you need to disclose in writing to that payor who your client is and who your obligations run to, and that's at least the minimum that you have to do there. Looks like we have a question or a comment there from Malcolm Scher.
Yeah, a fee arbitrator, Malcolm Scher. I know Malcolm Scher. Hi, Malcolm. He says, as a fee arbitrator, I've seen third-party payor issues come up in fee arbitrations. I bet they have.
Yeah.
You would
definitely see that there. Yeah. So, okay. Any other questions before we go to the next topic?
Yeah.
Is there anything else? Okay, you want to read this one, or you want me to read it, Carol? Number 2?
Okay. Yeah, number 2. So in the next transaction, Mordred comes to you and says he liked the work you did and he wants you to represent him. So this is the guy you weren't supposed to be representing the first time, and now he says, you did such a great job, I want to hire you. And it's the selling of a parcel of property that it's a 1031 exchange, and it'll be used for a new business that sells marijuana, holy grail marijuana. Wow, that sounds like it's probably good stuff, huh? And so he, believe it or not, he doesn't have a lot of cash. I guess his marijuana isn't that great. And because they seem to have a lot of cash. And so he wants to give you a 10% interest in the Holy Grail. And if the deal closes, and all the free samples forever you can have. I don't know about you folks, but that sounds pretty good. So the question becomes, can you accept that arrangement? What if he wants to pay you a month? And this is the one that I'm going to address. The monthly retainer of $10,000 plus free samples. Is it a true retainer or a flat fee? What do these terms mean? And last, we raise the issue of, what if you find out that this HGM marijuana business is going to be right next door to the future site of an Amazon warehouse? If you've been reading the financial news, you know that Amazon is now moving a lot of their fulfillment centers into suburban areas more. They're going to be moving out to the suburbs because people are moving and wanting to work and live in the suburbs. So say you find that out, okay? Of course, it makes the property more valuable, right? So with regard to the, any kind of deal where you're getting something forever is not going to, in the long run, be valid. Because first of all, forever, the business, it could go out of business. But second of all, the value of whatever it is you're getting forever can just go up and up and up. There was a case where it was a real estate transaction, actually, and they said to the lawyer that he was going to get a certain percentage of the money that was made in the shopping center forever. And he got it for about 3 years, and then the court stepped in and said, get out of here, because the people who were the clients complained. I also want to look at the 1.5 and 1.15, because that's top 1.5 and 1.15. It's a little confusing, those. I don't know why we did it that way, but 1.5, 1.15, and 5, there's another one with a 5 in it. But the bottom line is that it gets to the fees and the unconscionability or conscionability of fees, okay? And so we talk in 1.5 about what a true retainer really is, because this is actually a good question too, because it kind of mixes up the concept. It almost sounds like a flat fee, like every month they're giving you $10,000. But generally in a flat fee or an evergreen retainer, right, an advance fee of $10,000, what is it really? We don't have it designated, which is the first bad thing. It's not a true retainer, because what we don't say in here, a true retainer, remember, you do not bill against a true retainer. So if someone gives you the 10,000, you keep it, go out and buy yourself something nice or go on a vacation. And then when they ask you to do work, you give them a bill and
Yeah, so
you don't deduct it.
In real estate transactions, we don't really have true retainers. It's kind of a specialty. I mean, you might get it, Carol, if somebody wants to keep you on, literally keep you on retainer because they want to keep you from being adverse to them or just have priority of your time.
You might see it with real estate in a bankruptcy of big clients that might want a certain lawyer to do workout deals because they're good at it. You might see that with real estate. You see it with criminal law. You see it with, yes, with ethics. I've had people.
Maybe with a big antitrust case, you'd see it where they're like, oh, you know, this is the leading expert in antitrust or First Amendment cases. And so the New York Times has on retainer this First Amendment expert because they need that person and they don't want them busy on something else.
That's right. So if it's not a true retainer, then, you know, what is it? Is it a flat fee? Well, to do what? Because we don't talk about the fee agreement or what it says. And if you look at the flat fee language in 1.15, it's very clear of what needs to be said to get a flat fee in section B1. The client has a right to require it be deposited in an identified trust account until the fee is earned. And the client is entitled to a refund of any amount of the fee that has not been earned. So that language you have to put in. It has to be in to take a flat fee, and advance fees now have to be put in the trust account. Sometimes people ask, what happens if I have a contract from before 2018? I already took the money, the advance fee, and I put it in my operating account. Do I have to turn around and put it back in the account? I had a lot of questions like that when we first passed the rules. We haven't seen anything on that because the law's unclear on that. What do you want to do if you want to be safe? I guess put it in. But, you know, people were taking money out of their retirement accounts to do that. So I have not seen the bar prosecute it, and I'll turn it to Robert Miller.
So a couple other points on this. So this idea of getting a 10% interest in AGM, whether as a bonus payment if the deal closes, or if it's your only compensation. So there's a couple points on that, some of which Carol has already kind of touched on a little bit. But, you know, if 10% in HGM is worth, you know, millions of dollars, and your bill would have only been $10,000 or $20,000, the issue is it a proportionate representation? Is it a good approximation of the value of the services rendered? Probably not. It's too much. I mean, you can't get some grossly disproportionate amount. I mean, if it's arguably close enough, I think that's probably not something that anyone's going to complain about. The person who's going to complain about it is the client. So if the client is happy and they think that it's a pretty fair deal, then it's not going to come up. But if you're saying, oh, I'll take a flyer on this thing and I'll get $1 million for $10,000 worth of work, you know, maybe you can get some, you know, like obviously when people get a percentage of a settlement, you know, they're taking a risk and they get a better result than they get a better payment. So that's acceptable. But if it's many multiples times what the actual value of the performed services are, then the rules don't permit that. So that's one problem. And I think that's somewhat mitigated if it's just a small percentage and it's a bonus payment and it's a great result. I think you can argue that, well, hey, I took some chance with this, and so I got a little extra money because I might not have gotten paid at all on that. But the problem with it being your only payment is that you don't get paid anything if the deal doesn't close. So now you're effectively in business with the client, and your judgment is now a little bit suspect or clouded, because if somebody says to in the deal later on, you sign it up and everything's great, and all of a sudden they're saying like, oh, well, there's this hazardous issue we discovered in our due diligence, and we want you to indemnify. We want the seller to indemnify for all these problems, and maybe it's a reasonable request and maybe it's not, but the person who bears the risk of that is the client. You just have the upside. So you don't get paid. I mean, say you were going to get $100,000 when the thing closed, would be your normal fee, or you get 10% of the deal, you're going to lose all your money. You're not going to get paid for that transaction. So your interests are somewhat adverse to the clients. You've created this adversity by taking a percentage of the deal instead of your normal fee. So you would then need to go back to the client, explain this situation to them, tell them they could hire an independent counsel to advise them on this issue and get them to waive that conflict, because now you're in business with the client, which would be the requirement if you're, in business with the client and you're giving them advice that is potentially adverse to them. And it's a very difficult position to be in. I think it would be problematic for anyone to actually do that over and over again. I mean, that, at every juncture, theoretically, you could be adverse from the initial time when you're involved in this deal.
And it's not just real estate. It's like if you take Google stock or you take anything, you have some of that adversity because you're no longer sitting back and using your good judgment. It's your judgment about what you're going to gain. And so that can be a problem. We also bring up the issue of advising on marijuana and that sort of thing. We know now, because we put it in the rule 1.2.1 in comment 6, that you can give advice to people that want to try ventures that may or not be legal. People ask me to do that all the time in ventures that might be the unauthorized practice of law. So we talk about it in comment 6, and this was the rule that I was the lead drafter on. So I remember putting that comment 6. And by the way, this is one of the only 2 rules Supreme Court sent back for more because they were concerned about it. So we have this comment, and it says that you can advise on where the law might conflict. Federal law, state law might conflict, and tribal law. That was a new one because there is tribal law, and we've never acknowledged that in our rules before. And we say that you have to talk about, the issues with the client, because that's part of your duty of competence and advice. I would also say with marijuana or the like, if you're doing that, and could be a lucrative business, you can certainly do it, but there are tax laws, banking laws, and for the lawyer, I would say it's potentially assisting in a crime. Not that they're criminals that do marijuana, but maybe you have somebody who doesn't just sell marijuana, if you know what I mean. They could be involved in other things. So I think you just have to be particularly careful where you have an all cash business. A lot of it's cash, right? Because they can't use the banking. They might want to pay in Bitcoin. There's a lot of issues that are going to come up with a client like that.
Well, it's also illegal under federal law still, even though it's legal under state law. So there's that.
Right.
I mean, there are memos at the Justice Department that they're not going to prosecute, but as we've seen, the federal government can turn on a tweet, and
right.
I mean, the president could tweet that we're not doing that anymore, in which case I don't know what happens. I mean, are they going to start prosecuting people? It could happen. I would be concerned about that. I know there's lots of people who practice in that area, and it's a burgeoning area, and people are pretty happy to do it. But
well, remember though, but Robert, no, president could tweet all he wants, but the entity in charge of lawyer discipline is, by everything, law, this California Supreme Court. And that's a huge issue with federal and state people wanting to discipline lawyers. It came up with SOX, the Sarbanes-Oxley.
yeah.
What ethics rules could they impose? But we decided it is the Supreme Court, so the feds, and he can tweet all he wants.
I'm not talking about discipline. I'm talking about going to prison. I mean, you could be an accessory to a crime. If you take,
You're saying
if you take the cash. I'm not a criminal law expert at all, but I'm just saying, if you take the cash and the cash comes from a federally illegal enterprise,
yeah,
you're participating in a crime. I mean, obviously that doesn't happen, and it hasn't happened for years. But
yeah, I wouldn't worry about it. But you're right. If it suddenly became illegal, well, then people would have to adapt. I mean, they would no longer be able to do that business.
Yeah. And we're far afield. Dean Christopherson asked a question about when I was saying that if the client declines to spend the money to get an independent advice as to the conflicted issue, it says what happens then? I mean, all you can do is advise the client that if you think there's a conflict and you advise them that they should, it's just like any other conflict waiver. You say to them, you may want to get independent advice as to this issue, as long as you describe what the conflict is and advise them that they may want to get independent advice. You can't force them to do more than that.
Well, with any conflict, you're advising on the reasonably foreseeable adverse consequences to the representation. So you're not just saying, here's the conflict. I mean, you're also saying, here's the issues. Here's why I could be,
right.
biased.
You have to explain in terms of the client can understand what the nature of the conflict is and why and how it can affect them.
Right. And then you're in pretty good shape. It's the 1.8.1 business transactions.
Right.
Should
It's
we
'cause
move
you
to
are in a-
3?
Yeah, let's go on.
Okay. So 3 regards an issue that I think is, I wish we somehow deal with this better than we do. It's about Yelp reviews. Okay. And say you've worked with Mordred and you're afraid that, you know, he's sampling too much of his own product, the holy grail marijuana. You're worried that he might be difficult and trash you on his Twitter feed. So he has many followers. You don't want your representation tarnished. So what does he say? Or what do? You put in your fee agreement, in the event of a dispute involving the legal services hereunder, the parties agree that they will not disparage each other to third parties in writing in any medium, including social media platforms. This provision does not restrict clients' right to make a complaint against an attorney with a state bar. Well, at least you did that. And what do? You tell your associate to prepare the letter, and she strikes the last sentence out. Oh, so you got duty to supervise issues too. Client agrees, and she puts, client agrees it will not sue the attorney for malpractice or any other claim at any time. And so, you know, I think the problem is you have a duty of confidentiality. And the duty of confidentiality means that you cannot raise issues like that. This was recently brought up in a couple of, I'm trying to get the numbers, LACBA, LA County Bar Association, Ethics Opinion 525, and the Bar Association of San Francisco Opinion 2014-1. It's also in the Civil Code section 1670.8. And it basically just says you can't force people not to evaluate your product. And really, lawyers can't do anything. It really makes doctors angry about this. The next thing I raise quickly, and you can talk more about this too, is a duty to supervise, which comes up because you have an associate who, of his or her own volition, turned around and changed an important provision. And it's always the lawyer's duty to supervise. So our new rules, we never had the duty to supervise in our rules that way. It was only in a comment section to the competence rule. Now we have it as 3 separate rules. So we are seeing now, I'm seeing in my practice, more prosecution involved in a lack of supervision. So I'll turn it to you, Robert.
I mean, I think we always had a duty to supervise, but I think it's explicit now under the new rules that you're responsible for what your paralegals and your associates and even your colleagues that, you know, sending things out under your name, that you need to review all that and make sure that it meets whatever the standards and obligations are. On this question, I mean, the best practice would be just ignore it. I mean, I don't think you can really do much about it. I don't think there's anything to be done about the Yelp review. I mean, I guess you could engage, or the Twitter feed or whatever, you could explain, as some people do. I've seen that where people try to explain what happened to put it in context, but you can't reveal attorney-client communications or anything about the matter when you do that. So I think it's a little bit futile because you can't really tell your side, which would be to explain why the client screwed up. I mean, that's becomes impossible.
It's
That's
bad, and I don't like it because, to me, you are allowed to reveal confidences to defend yourself in a bar matter or in a legal malpractice matter because you're being attacked. Why, if the client's attacking you on Yelp, why can't you, to the extent of the attack, respond? Doctors have brought lawsuits on this, and I'm not certain with them what the law is on that, but they're furious about it. So, you know, to me, it just doesn't seem fair that we have that right now. And I see that maybe changing, but not with our strict confidentiality rule. We don't have the exceptions that the ABA has in their confidentiality rules.
Yeah, I'm not sure what you could even say if you wanted to say something like, I performed at the very highest level and I did everything I thought was I mean, I guess you could say something like that, but it's so generic that it's not very meaningful. You could say some very generic statement about what a great lawyer you are, but that's kind of it.
That's about all you can do. One other thing that it's the reverse, like you also can't create fake good reviews. Or for example, post pictures of yourself with celebrities or things that you've never met. So I'm not allowed, for example, to say, you know, Robert, I want you to post a great review of me because you've never used my legal services. And lawyers were doing that, having their friends say, this is a great lawyer. And then the bar started with one person, hey man, you know, who are these people? Are they clients? And then people stopped doing it because it's easy. You could just type all day on Yelp or wherever and have all your friends write how great you are. And then you sound like a great lawyer. And that's misleading advertising is what it really is. It goes under the 7 series of advertising because it's false and misleading. So the bar does not allow also you to post fake good reviews.
Yeah. It looks like there was a question from the last one. I just want to make sure we cover that. Lois Kadush says, does anything change if the attorney is also a real estate broker? I think that's from the last question. No, nothing really changes. I mean, I don't think that matters.
No,
So,
because if you're a real estate broker and a lawyer, you're still held to the lawyer's standards.
no,
You
if
can
the other,
prosecute.
if the client, I think the question is if the client is a real estate broker.
Oh, okay.
So I don't think that changes anything. You still have the same duties.
Yeah.
Yeah. Okay. I think because we're a little short on time. I think we're going to skip forward and maybe come back to that if we have time, and we're maybe go over to 4 or 5 and then go to 6.
Okay, we'll go to 6. And so that is, you're representing Knights in a development project. And after completion of the project, Knights sells the project to Saxon Invaders Equity Fund. Oh, I like that name. Robert put that. That's a good name. So what happens? Problems arise with the building, and Saxon believes it was ripped off by Knights. You think you did a great job. Well, there are issues actually, because you told the client not to disclose certain environmental issues. The insurance company steps in. So it really raises the issue of insurance and, you know, what happens when insurance companies become involved. And that has been hotly debated. I mean, for a couple of years with Travelers Insurance Company, and I was the expert on a lot of those cases. But there is an opinion, and it's the State Bar of California formal opinion 1995-139. And it basically says that we are not going to require conflicts waivers and things with insurance companies when you have an insurance company paying for something, because the policy itself is enough disclosure, A, and B, the lawyer has to always, a lawyer who's paid by the insurance company but representing the insured, has to default in favor of the insured with their duties, always. So it's in that opinion. So if that's the case, then they don't see a problem. And when you look in the ethics rule itself, they have a comment about how our conflicts rule is not intended to basically mess around with the duties between insureds and insurers. So that has not changed. It has not changed with the new rules. Robert?
A couple other points in here. You think you did a great job for Knights by advising them not to disclose certain information regarding an environmental issue at the project, and that is one of the issues in Saxon's claim. So there's actually, in addition to the conflict with the insurance company as a third-party payor, there's the conflict with the client, because you're still representing the same client, and this is an issue in which you are potentially, your malpractice coverage is potentially implicated because you told the client something that actually leads to the lawsuit itself. So you would have to, I mean, you probably should recuse yourself from this matter is the issue, because you can't really, you really can't represent the client because your interests are adverse to the client in this litigation. So that there's that problem.
Right.
And then there's that it goes on. Trust Us calls you about your investigation. What information can you withhold? So if there's something in the file that is potentially damaging to the client or to coverage, you can't disclose that to Trust Us. I mean, you again, this is your obligation is to your client. Your client here is Saxon, or sorry, so your client here is Knights, and you know if Knights has something in their file about this environmental issue or anything else, you can't show that to the insurance company. That might show that there's not coverage because there was fraud or something like that that's not covered.
And that is so, like, people always think, how can that be? Because they're paying, isn't that defrauding the insurance company? But you have to think of it in terms of who is your duty going to be to when you have really, in a way, two clients. You're so used to dealing with the insurance company. The insured is someone you might not have met till their deposition. So people feel that sense of loyalty to the insurance company. But the real loyalty, obviously, or we can't have insurance, the real loyalty has to go to the insured.
Okay, next question. What if Trust Us wants to tender and sue other parties but Knightsbox? Again, your obligation is to your client, and that's, you have to do what your client tells you to do. There may be contractual issues between the insurer and the insured that talk about who controls the litigation. That's not necessarily part of what your obligation is to your client, though. I mean, that's an issue between the insured and the insurer. What should you do about, we already talked about, what should you do about your personal involvement in the claim? Do you have a conflict? Yes, you have a conflict. So, yeah, and that's I mean, to me, that's the biggest problem in this example here, is that the attorney has a conflict and shouldn't be involved at all.
Right, because it's their work. And you see that a lot with lawyers who have drafted patents. Like, it comes up in a lot of different areas of law. And then they're having, someone's attacking the patent, they've done the work. You just cannot represent the client faithfully in that.
Yeah, I mean, you can see this in real estate cases too, where you've drafted the complaint, you've drafted the contract, an issue comes up, and I mean, more often than not, I think it's a contractual interpretation. It doesn't mean that you committed malpractice in drafting the contract. I don't think you have to recuse yourself. But in this case, where it's really about like a fraud claim against the client, and you advise the client to make that statement or to not make that statement, I think you really are kind of stuck in there. If it's, there's a kind of a continuum, I think, between I drafted the contract, now there's a dispute over the contract and we're being litigated. That happens with some regularity. I don't know that you necessarily have to recuse yourself from that.
Robert, I wanted to bring up Jody Udine. Hello, Jody. How are you? I know Jody. It's so nice to have all my friends here on this. He asked, does a client have the right to see reports the lawyer makes to the insurance company or other communications between the lawyer and the insurance company? That's very interesting to me. Clients' rights are not ethics, because ethics is really more lawyers' duties. Clients' rights tend to be contractual. The duty that would come up with a lawyer would be the duty to communicate a significant development in the case. So if the lawyer is just making a report, we have a deposition going and we're moving for summary judgment, the client's going to know probably their deposition is coming in the summary judgment. So a lot of it would be contractually based. Like, what does the insurance policy say? The lawyer's duties ethically are going to be more towards the duty to communicate. What do you think, Robert?
I think that specifically answering that question, I think the client has the right to see what you're doing. I mean, if they ask for it.
Yeah.
And I don't think the insurance company. I mean, again, you're working for the client. So if
you're working for the client, but it's going to be, it seems like, I guess from an ethics perspective, I'm looking at the lawyer's duties. The client asks for a document. If they've been billed for the document, they'd have a right to see it.
But it doesn't matter who pays the bill. I mean, if the client wants to see something, they get to see it. It's their work product.
That's right. The insurance.
Yeah, it sounds like
I don't think that matters if the insurance companies pay.
Yeah.
I think the client. Yeah.
Malcolm has a comment. He says, lawyer must report all important information to the client. Lawyer should send copies of letters sent to the insurer. Yeah, that's right. I agree with that.
Yeah, so if it's a minor thing, it's a nothing. If the client wants, you just tell them or show them. If it's important, they'd have to know anyway. So it just all gets to the lawyer's duties and the contract itself. So let's look at number 7, which talks about, in your course of representation of Knights, Saxon produces hundreds of thousands of construction documents, and they have to get scanned, right? And so what happens? You have a vendor that you've used in the past. They're a very good vendor, but oh no, the client, Guinevere, has a buddy, and they used a company in Sirmaru. What is that, Robert?
That's the country. That's Wales in Welsh.
Oh, okay. I didn't know that. So Wales and Welsh. And you then realize that they are not very good. So the question becomes, now what do you do? This can happen for sure, not just in real estate either, is what do you do? Because these are sensitive client documents. That to me is a big one, because I wouldn't want to be liable for the documents if something happened to them. And if you look at the typical, I looked before today, yesterday, because I knew I was going to talk to you folks about, I looked on the Google Cloud contract, and it wouldn't print out, by the way, which kind of made me mad, but I looked through, it has hundreds of provisions. It's hard to understand. But when you start honing in, you see provisions that where Google's basically saying, we don't have any liability if these documents get lost. And they can go to Australia, they can go to Hong Kong or wherever, which they could lose them or go bankrupt, because they don't just keep them all in Google in San Jose, which is what I initially thought. Wait, don't they have some kind of big server and all of your cloud goes up there? No, it goes all around the world. And that's bad. So you have jurisdictional issues if you ever wanted to sue. And also in some of these contracts with maybe the Wales company, you'd be surprised that there's clauses of what you upload they own. Now that's not good, is it? So, because you could be uploading all kinds of things. And so you just have to know that there's lots of sneaky provisions, even in the Google ones still. I'm not sneaky in that they're there, but you've got to really read, and I had to click through and it was hard to get to some of the provisions. Robert?
Well, again, this is from one of our colleagues who does litigation, and this example where there are cheaper vendors who are from other countries where maybe, you know, they don't pay people very much, or their English language skills aren't very good, or various things like that. And so you could save a lot of money. I mean, particularly if you got, you know, hundreds of thousands or millions of pages to scan, it could be a significant cost in the litigation. And so it could be a whole lot cheaper. It could be a small fraction of what it would cost to use a first-class vendor. So I don't do this kind of work myself, but I understand that these are significant cost items in large document cases. And it's very important that it's done right, so that when you do the OCR scanning and you're looking for search terms, you can find what you're looking for, and that it's done properly. So there's two conflicting issues here. One is, you need to, just like you need to supervise your paralegals and the other attorneys in your office, you're responsible for the vendors too. So if you hire a shoddy vendor and they do a crummy job because they're the cheapo vendor, you're responsible for that. And if it comes back all messed up and you can't do your job very well, or you miss important documents because they weren't scanned properly, you are responsible for that.
And that, you know what, Robert, you're right. That's in 5.3 in our new rules, where we talk about non-lawyer people. It gets to vendors, so yeah.
Yeah, it goes to vendors too. On the other hand, the client, you know, the client's always right. It's at some level. And so the client says, hey, you know, my friend told me that there's this cheapo company and they did a decent job for them. You don't know maybe that case only had 500 documents. We don't know. So maybe they did a good enough job in a little case. So you really, I mean, you need to, if the client makes you do that, you need to be very clear with the client that you're doing the best you can. I mean, if they insist that,
Robert, I don't think you can do the best you can. I think it has to be, if you really are worried about that, you wouldn't work on that case, because in a big litigation matter, those scan words better be right. So, and you have the responsibility now in the world.
Yes. Yeah, I mean, you cannot palm off that responsibility, but I think you can explain to the client what the pluses and the costs and benefits are. I guess you need to convince them, is what you're saying.
Yeah.
Again, I don't do litigation, so to me this is a little bit beyond this is from a colleague of ours that.
Well, you know, I think with this cheaper stuff, it's just, for me, you have to be willing, as I call it, to let go of what you want most. So you want this big case that brings in money, but sometimes you got to let these big fish go, because you might have real liability later down the road. So that is, especially in a pandemic, when lawyers are more apt to take cases they shouldn't, clients they shouldn't. I'm already seeing that in my practice. And then they end up having trouble. This is not, to me, the client's decision. to pick a bad vendor. Not, and particularly since the bar now is really doing a lot of ethics opinions on technology and the lawyer's, responsibility for that technology. They're taking it seriously. So it's just something to be careful of. So should we turn to 8?
Yeah, let's go on. We have maybe 10, 15 minutes left. We'll try to get these last 2 in.
Okay. So during the litigation involving Knights, you hire a new lawyer. Unbeknownst to you, the new lawyer previously represented Saxon in several pieces of real estate litigation in a different matter, right? And has relationships in its general counsel's office. Can this ethical conflict be cured by creating an ethical wall? Can the other firm disqualify your firm? Does it make a difference if the new lawyer is over 70? Okay, I forgot why we put the new lawyer is over 70, Robert.
I think there was there a law, there was a new rule that was pending at the time that you were looking at?
Oh, you mean like on the impaired client?
On the lawyer over 70. Anyway, I don't. That was your suggestion at the time. I forget why.
I think what we were doing was we were probably talking about the fact that lawyers are representing more elderly populations, and that sometimes you have an impaired client. We don't have an impaired client rule in California. Certainly, we have many lawyers 70 and over practicing who are just fine.
But let's talk about the ethical conflict and the ethical wall.
Yeah, and so this brings in the former client, and so to see if there's a substantial relationship, you first look to see if there's a substantial relationship with the matters. And I always just ask, are the facts of the two representations similar? Do they involve the same transaction or the same factual dispute? What was the scope of the first representation? Are the legal issues the same? And if the answers are yes, they're the same, you got a substantial relationship. And if you have a substantial relationship, then pretty much there's disqualification. If there's not, then what do? You look to confidential information. And the question becomes, that can be used against the old client. How involved was the lawyer? And these standards that I'm telling you are all from California case law that I just narrowed down into bullet points, which are
and the rule actually does a pretty good job of kind of creating the decision tree for you. Like you look at, is there a substantial relationship? And then you kind of decide that. And then the question is, do you have access to confidential information? So you can, and then if you meet those standards, then you can go ahead and create an ethical wall.
Robert, except what it doesn't do, it does have that decision tree, but what it doesn't do is explain what confidential information can be, really. It does, we have comments, but how involved was the lawyer in the former client's case? How long was the lawyer's representation of the former client? Did the lawyer have a direct and personal relationship with the former client? Is the information obsolete because it is old? Is the information just general knowledge? Is the information playbook or poker tells? Meaning, their body movements when they're going to settle and that kind of thing. And so that all comes as a distillation of the case law.
So maybe we should give a little example of what would be okay, what would not be okay in that, because that is sort of a little bit of a judgment call. So for example, if you hired a younger attorney from another firm that represented, this giant corporation, and they were involved in some aspects of representing them, but not substantially related to this. They did some litigation. They were the junior attorney. They didn't have substantial client contact. And now they're working for you, but not even adverse to this client. They're just working on a completely unrelated matter. You could just create an ethical wall for that person.
For the most part, it depends on what they learned when they were at the old firm. That's really the key. In the old days, we would just say imputation, period. But now, in a problem, and no screen's going to satisfy. But now we're different because there's so much movement between law firms. What happened in that? What did you do? If I worked on the case, what did I really do? Look up a statute of limitations and never did any other work? That's different. How involved was I with the client? What am I bringing? How much am I tainted with? And that's what's looked at. And if you do early screening, you're more likely not to be disqualified.
Yeah, and that's the example I was using, is where they were not involved factually in a similar matter. They didn't have much client contact, and they're a relatively lower level person in that other litigation. Now, on the other side, on the other hand, or the other end of that spectrum, is you hire the former general counsel of that adverse party. Now they work for you. they know all the senior people, they know the strategy, they built the strategy, that, you know, everybody reported to them. And, you know, that is a case where even if they didn't directly work on this matter because they weren't there at the time, but they know so much about that adverse party that it would be very difficult to meet the standard of saying, we don't have any information because you're not directly involved in that specific matter. So that's kind of, I think that's where would be an example where you wouldn't meet that test. Does that seem fair, Carol?
Yes, very fair.
Okay. I would say those are the two kind of polls that I would look at. And I think by far the more common, at least in my practice, is it's a junior attorney or even, you know, mid-level attorney who doesn't have a direct relationship with the client and doesn't have a direct relationship with that matter. You know, that seems to me like a case where you could make the argument that, yeah, we just build an ethical wall around that person and they just won't be involved. And that you can go
Yeah,
on.
I just see the long-term trend in some ways of loosening conflicts, although with some of the newer conflicts cases with former clients, the Supreme Court has shown and the courts have shown they're going to still enforce conflicts rules and that they still haven't become completely loose. So that's kind of interesting to me. Let's look at, we're on 9. Saxon responds to one of your document requests and produces hundreds of thousands of documents. One of the documents is an email from the general counsel addressed to an unfamiliar email address outlining the facts of the claim. This email is damaging in that it shows it may have been aware of the issues that constitute fraud. What are your obligations in this situation? And it looks like it's the inadvertently transmitted writings rule, which is 4.4, and we just say you've got to refrain from examining the document any further than is necessary, and then you just notify the sender. It's very interesting to me because what we don't do in that rule is say, what do you do with the knowledge inside of your head? I mean, you leave it up. It's very much up to the individual. This is not, you rarely see this prosecuted, Robert.
I think it's just good practice that if somebody sends you something by mistake, it's the rule too, but I mean, it's, you know, if somebody sends you something by mistake and then they write you back and say sorry, or it's obvious to you when you're reading it that it's a, you know, a privileged document, you should just stop and send it back.
Yeah, and we say in 2 that we don't address the legal duties when you receive a writing that may have been like maybe purposely disclosed by the sending person. Like you could have somebody in the organization who's pissed off, like with a drug company. There's a lawsuit, drug company doesn't produce documents they should about the drug, and someone then turns and purposely sends things over. They're saying that is not necessarily addressed by the rule, because that would just be addressed by the judge in the case. How are they going to handle those documents that come? And they come sometimes. Yeah.
And you know, again, I'm not a litigator, so this has never personally happened to me, but you sometimes do get things, communication. And with email, it's very easy to fire things off across, and, you know, the bell can't be unrung, but at least you can.
Oh, it can happen now with it, you know, tweets and texts. People send all kinds of stuff now. I think the key is the speed. You have to stop. The faster you can send, the more you need to stop and think before you actually press send.
Right.
So let's see, how many minutes? Oh, we only have a couple of minutes. Do we have enough time to do one more?
Should we do what, 4 or 5? I think we have.
Okay, that sounds good.
We
So
maybe one more.
Sorry?
One more, I think, yeah.
Okay, one more. And so this gets to the continuing client 4. So rather than read the whole thing, since we really don't have a lot of time to do that, it's on the hour, but let's talk about it. It gets to, you're representing somebody, but then what happens, you have represented somebody in the past, but you stopped representing them, but you do a deal with them. So you stop representing them. They're what I call the continuing client. And that is very interesting to me, because when do your duties stop? When do they stop? And when do you have duties to what are almost third parties now, because it's a former client? The state bar case law on that, the discipline, is very clear that if you've had a former client and it's pretty close in time, then even though they're no longer a client, the litigation or whatever you were, the deal is over, you still have a fiduciary duty to them. And your lawyer duties are kick in. It's like you're still a lawyer and you can still be prosecuted, because you can't be prosecuted if you're not acting as a lawyer, because there's nothing for the bar to prosecute. You have not violated a rule of professional conduct because you haven't been acting as a lawyer. But we say in the bar that you have a continuing duty if it's fairly close in time and they rely on your expertise. Robert?
Yeah, I mean, there's actually a case where an attorney had represented in the past a real estate client in a deal, and then, years later did a deal with that person, and the bar prosecuted them for that behavior. The other thing in here is about that, one of the other subparts of this is, that this person has had several bankruptcies in the past, and what do you need to disclose? So you've got either a present client and a former client, and the present client wants to do a deal with the former client. You have confidentiality obligations to that former client, and you have disclosure obligations to the present client.
Mm-hmm.
So you need to get a waiver for that.
You'd have to, and they'd have to be willing to sign it and let the other side know about the bankruptcy. Otherwise, you couldn't do that deal.
Yeah, I mean, because you have an obligation to both of them. So even when you're representing the new person, and there's another person who you're not representing, you need to get that waiver, and that's just standard conflict waiver situation. The other thing is, the other part of this is, you can draft a partnership agreement if you get the proper waivers from both parties. That happens all the time. But even with the present client, former client, you'd still need to get that conflict waiver to represent the new client and draft the partnership agreement for both of them, and then be clear to the new person that you're representing only them, and to the old person that you're not representing them. I mean, so you just need to be aware of exactly at all times who you're representing, who you're not representing, and if there are conflicts, you need to document that and get the waivers for that.
Now, something says we're supposed to go till 11:30, but I thought it was 1 hour 11. Is Teresa or?
Yeah, I think
Randy?
I think that's an overhang. I was looking at the calendar and it looks like that is showing up for a lot of programs.
Yeah, we give extra time in case there's extra introductions or Q&A. I mean, you guys have satisfied the 1 hour of MCLE. If you want to go a little longer, and people want to stay on, I'm happy to hang out.
Well, I don't mind doing the last hypotheticals.
Yeah, we can do one more. Yeah, let's just finish it out.
Yeah, that way we get through all the hypotheticals for you folks. And if you have any questions, you can always email.
I think that's a compliment, by the way.
Oh, okay, good. So let's talk about 5 then. 5 says, Modred comes to you with a new deal where he and 2 neighbors, Merlin Ambrosius, Robert, you and these names, and his sister Morgan LeFay.
No, these are real names. This comes from the legend. I didn't make these up. This is
are
all real.
selling individual adjacent properties they own to Camelot Industries. Camelot will only purchase all the properties, so all the parties and parcels will need to close. Merlin and Morgan are not represented. What do you do if you're only representing Mordred, but Merlin and Morgan have told you they will not have an attorney? What do you need to disclose? What duties do you have to unrepresented third parties? And I will just say with this, because we've talked a little bit about the tag-along client, but really it's the prospective client rule. And we get to prospective clients and how you have duties of confidentiality, even if you don't take them on. But I will always bring up just in general too. People always wonder, well, what duties do I have to any third parties? Well, what I did was I decided to check what duties in our rules that lawyers have to third parties. And wow, if you look at every single rule, the sexual harassment rule, these are third parties. Misconduct in another state that's non-client related. Opinion letters go out to third parties. Duties of candor to the tribunal. Duties to represented and unrepresented people. You can't file actions merely to harass someone. Those are all duties to third parties. So our rules are filled with duties to third parties. So in this one, the question becomes, of course, have you, the usual factors of whether there's an attorney-client relationship. Robert?
Yeah, I mean, the reason we skipped over this one is because some of these issues were discussed in 1 and 2 above, which is the same answer, which is if there are people who are not represented in the transaction, you need to be very clear who you're representing and who you're not representing, and disclose to those people in writing that you're not representing them. So even if they say to you, hey, we're not going to pay an attorney. And I've actually had this happen to me too, where people say, hey, you know, I don't, you're doing a great job for landowner A and I'm landowner B. Just keep at it. You know, I'm not going to worry about it. It's like, you know, be very clear. I'm not representing you. I may cut a better deal for landowner A. You know, you know, if landowner A gets a little better price than you, don't come looking to me. I mean, you don't have to say all this, but this is essentially what the issue is that they'll come back and say, hey, you treated A better than B. You know, and you know, I thought you were representing me. So that's where you have to protect yourself, is that claim cannot be made against you. I want to talk just for one minute about the prospective client rule, because that's new, and that is sort of a troublesome thing when people call you up and say, hey, you know, you were recommended to me by landowner A, you were recommended to me by Merlin, and I heard you did a great job, and here's all my facts, and here's all my issues, and what should I do? And you start answering their questions a little bit because you want to get the business, and then they go call some other attorney, and they use that other, I mean, like, all of a sudden, what do you do you have to run a conflict check on that person before you actually answer any of their questions?
You should have done the conflicts check before they even spoke. That's the problem.
But the point is, they call you up and they say, hi, my name is Joe Smith. Merlin recommended you. Do you have 5 minutes to talk? I don't really want to say, oh, I can't talk to you. You know, I mean, you need to get enough information so that you can run the conflict check, understand what the issue is, and not give them any advice.
Well, you just say, okay, look, what's the names involved? And then they tell, and you run the conflicts check, and if it looks bad, you don't give them any. I mean, I admit that that's hard to do. And sometimes people call me, and I just talk to them without checking.
I know you just talk to people on the phone. I can tell you that must happen.
Oh,
Everyone
I talk to people. Of course I do.
does.
But I know when they say attorney X, if I'm dealing with attorney X or have, because I represent lawyers, so it's easy for me. It's harder for you and people who have a lot of different names to pull up. But unfortunately, that rule does say you do have duties to respect.
It does, right? It does, and I think it's a very difficult issue, and one we're going to have to learn how to do better, because it's new. You're a solo, so you know who all your clients are. You know, I have lots of partners. I kind of know, but I don't know all of them.
No,
and I have to run a conflict check. And so, yes, the first thing you do is I say I have to run a conflict check. But I think you want to get enough information, ask enough questions to know intelligently what questions to ask, like who are the adverse parties and what is this matter and what do I need to do? You can't just, you can't just say name, rank, and serial number. That's not going to do it.
No.
So anyway.
All right, everybody. Well, thank you so much for attending. We had a great time today. I miss all my friends from the Contra Costa County Bar Association, and we hope to see you again.
Great.
All right, thank you.
Thank you so much, Carol and Robert, for all of your amazing insight in our new world.
And thank you, Randy and Ann and Robert.
Yeah, thank you all.
Bye.
Bye-bye.
Have a good one, everybody. Bye.
Bye-bye.